We're going to start a new topic called reality of consent. What this term refers to is that sometimes you can find what appears to be a contract. In other words, there is a legally binding agreement, or apparently legally binding. There was an offer, it was promissory, it was reasonably definite, it was communicated, it was accepted. Somebody agreed to the terms of the offer, so offer plus acceptance, supported by consideration. There's a contract, right? Maybe. Normally the answer is yes. That is a contract and people are bound to their contracts. However, occasionally there is something so wrong, and this is rare, but there's something so wrong with the way that the party has reached an agreement that a court will give some kind of remedy in a way that simply is atypical because of the way that the agreement was formed was so wrong that honestly there never was an agreement, or else what happened was that when the agreement was made, it somehow got so altered that it doesn't reflect what the parties intended. So these are unusual circumstances, and you should be conservative when determining that they exist, but realize that sometimes courts go in and rescind, meaning cancel contracts, or reform, meaning fix contracts. Those are both remedies, and since, again, thinking back to our discussion of remedies, any remedy that isn't damages must be equitable. These are equitable remedies given only if damages would not be sufficient. There are 5 categories of these grounds which we're going to cover, and a court can come back and say, we're going to have some sort of a remedy here. The 5 that we're going to study are fraud, misrepresentation, mistake, duress, and undue influence. Fraud means that somebody made a false representation of a material fact with intent to cause the other party to rely on it. And the other party actually, reasonably, and detrimentally relied on it. Okay, so now in English, what is a false representation? Well, a fact is something that is capable of being proven true or false. What isn't it? It's not opinion. So an opinion is neither true nor false, it's opinion. Examples include, and let's go through these, this is a great car. Well, suppose it's a horrible car. Is this a false statement of fact? No. Great is an opinion. My opinion is that it's great. You need instead to find something capable of being proven true or false. Let's try a second example. This car has 18,000 miles. Can you prove or disprove this as a fact? Of course you can. Okay, so the second statement is capable of being fraudulent. If the car does not in fact have 18,000 miles on it, then this is a false statement of fact. Now let's try this statement. This is a good price for this car. Could that be a fraudulent statement? Is it fact or opinion? Can you prove or disprove it? No. Good to me, good to you might mean different things. Therefore, this would not be a claim for the basis of fraud. Therefore, just be able to distinguish fact from opinion. Notice that in normal everyday language, we use the term fact to mean, and it's true. For example, it's a fact that this is true. In law, we're not referring to fact in that sense. We're simply referring to it as something capable of being proven or disproven. The next thing to look at is that it needs to be a material fact. Material means significant. A material fact is one that would either affect one's decision to enter a contract or it would affect the price. If it's not that significant, then it's not material. So you must have a false statement of fact that is a material statement. Finally, what's a representation? Because you have to find a false representation for fraud. Well, a representation is a statement. It could be oral, it could be written. Could it be silence? For example, suppose I sold my car to you and the odometer said that it had 50,000 miles. I don't say anything about how many miles the car has. The odometer simply represents that. If it turns out the odometer has been fraudulently set back, If it turns out that the odometer has been set back so the car really had 100,000 miles, have I made a false representation? Well, I have made a false representation if I was silent and there was a duty to speak. Did I have a duty to speak? There's a duty to speak if a reasonable person would not have discovered that fact. So would a reasonable person have discovered the fact? No, most people do rely on the odometer of a car to be accurate. A reasonable person would have assumed the odometer was correct. Therefore, if I had known the odometer was not correct and I was silent, I have made a representation. My silence was a false representation. The additional elements to fraud: intent to cause reliance. In other words, my purpose was to cause you to rely on that false statement. What does that mean? It means that it was deliberate. It wasn't an accident. I did it on purpose. I did it to defraud you. I knew it was false. I knew it was important. I did it to defraud you, and I am doing it so I come out better. That shows intent to cause reliance. Finally, you have to show actual, reasonable, and detrimental reliance. What does that mean? Actual reliance means that the other party changed position based on the false representation. What does that mean? Changing position means that you either did something you would not otherwise have done, or you failed to do something you otherwise would have done. You actually rely on a false statement if you change your position. The second requirement is what it sounds like. A reasonable person in your position would have done that. A reasonable person, for this example, would have relied on the odometer. Notice, if it's not reasonable, you will not be successful in your fraud case. Even if someone lied to you, even if it was material, even if they are the biggest scumbag in the world, you will not win your case. Courts protect the reasonable expectations of the parties. If you are not reasonable in relying on that false statement, you will not be able to rescind the contract. Finally, your reliance must be detrimental, meaning you've been harmed. Normally, this refers to financial harm. It has to have somehow harmed you. If you came out the same or better, you'll lose your case even though some jerk lied to you. So which of these elements must you prove? All of them. If any one is missing, you will not win your case. Now let's talk a little bit about the remedies for fraud. Actually, you have two possible remedies. Fraud is grounds for remedy in tort and in contract. For example, rescission of the contract is cancellation of the contract. However, fraud also sounds in tort. You can also bring a tort action for it, and you could get damages. The victim of a fraud can elect which remedy he would prefer. He can sue in tort and know that fraud now is an intentional tort, so there's a possibility of punitive damages if you can also show malice. Or the victim can sue in contract and get equitable remedies, possibly damages as well, or have the court modify, sometimes called reform the contract, so it fits with what the parties truly intended. But you don't get both your contract and tort remedies. So, would you prefer to get your money back? Or would you prefer to get damages reflecting the amount that you've been harmed and possibly punitive damages stacked on top of it? Well, it's your choice, and it's the plaintiff's election whether they want to try to get the contract rescinded or they want to enforce the contract but get damages. Let's talk about negligent misrepresentation. Misrepresentation is like fraud, with the exception that it does not require any showing of intent. This means that the defendant's false representation could simply have been negligent. The remedies of reformation are available as in fraud, and negligent misrepresentation, as with fraud, sounds in both tort and contract. You could sue for the tort of negligent misrepresentation and get damages. You could sue in contract and potentially get the contract rescinded or reformed. Could you get punitive damages if you sue in tort? Tell me why not. Okay, good. Because it's negligence, not an intentional tort, so you won't get punitive damages. Now, negligent misrepresentation requires a false representation of a material fact. We've already talked about what a fact is, something that can be proven or disproven. We've talked about what material means. It means significant. We've talked about what a representation is. It can be oral or written. It can sometimes be silent if there's a duty to speak. Any of those can be misrepresentation, just as they are with fraud. However, unlike fraud, misrepresentation was made merely negligently, not intentionally. Now, recall what negligence is. It's a failure to exercise reasonable care when there's a duty to act. There must be causation and damages, and it must require that the other party actually, reasonably, and detrimentally relied on that misrepresentation. Again, actual reliance means that the plaintiff changed position. Reasonable means it was reasonable, and detrimentally means they changed their position to their harm. So you must show all of those things. Oftentimes, parties will sue for both fraud and misrepresentation. Misrepresentation in that case is sort of a backup cause of action in case the plaintiff can't prove intent. They have a backup plan, which is to sue for negligent misrepresentation. Let me tell you about a friend of mine who bought a car for the first time. This was years ago, before used cars had stickers on them indicating whether the odometer was correct or whether any warranties were being made. She's buying a used car. She doesn't know anything about cars, so she takes a friend with her to a used car lot. A friend to help her make her decision. Is this a good idea? Of course. Bring a friend who knows something about cars. You have their expertise. They can help you make a decision. Who did she bring? Well, I'll give you a clue. My friend's Catholic. She brought a nun in full habit. Now, what time of day would be a good time to get a good look at that used car? Well, my friend showed up at nighttime to look at the car. And she bought a car that turned out to be a horrible car. Later, she took the car to her mechanic after she bought the car, and it turns out that the hoses have been sprayed. I didn't know what that meant when I first heard this, but the hoses under the hood had been sprayed with black paint to make them look as if they were new and not cracked, and the odometer had been set back. Now, has my friend been defrauded? Has there been a false representation of a material fact? Well, there was no statement about the odometer being accurate or inaccurate. Was there a duty to speak? The car dealer was silent. Well, you could say yes, there was a duty to speak if a reasonable person would not have discovered this on their own. So yes, we could say there was a false representation. Is it material? Well, would it affect your decision to buy a car, or would it affect the price? Yes, if the car really had more miles on it than the odometer represented, you would pay less for that car. So it's a material fact. The second element is intent for fraud. Did the car dealer intend to induce Rita's reliance? The second element of fraud is intent. Now, did the car dealer intend to induce Rita's reliance on? The second element of fraud is intent. Did the car dealer intend to induce my friend's reliance on that false representation of fact? Well, we don't know. Don't make up facts. We don't know that the car dealer knew. It's possible that a previous owner had set back the odometer. A car dealer supposedly is an expert in cars and maybe will be able to determine whether they should have known whether the odometer was set back, but my friend's going to have to prove it. It's not automatic that she would win for fraud. How about the hoses being sprayed? Think about lifting the hood of a car and there's a bunch of rubber hoses in there. What color would you like those hoses to be? Well, you'd like them to be black and shiny, meaning they're not old and gray and cracked. But apparently you can just get a can of black spray paint and spray the whole thing and it looks black and shiny. Would that be a false representation of fact? Did the car dealer make any representation about the hoses at all? No. Did they have a duty to volunteer that information? In other words, were they silent where they had a duty to speak? Arguably. The problem with my friend's case would be reliance. Did my friend actually rely on what appeared to be good or relatively new hoses? No. Why? Because she never lifted the hood of the car. So even if you assumed or could prove there was a false representation of fact with the car seller's silence, my friend could never prove actual reliance because she never looked at the hoses anyway. The condition of the hoses did not affect her decision to buy the car. So realize that you're going to have to show all the representations of fraud or misrepresentation. And we're going to talk about what you have to show in order to win your case. So realize that you have to show all the elements of either misrepresentation or fraud in order to win your case. Undue influence requires unfair persuasion that overcomes free will. Unfair persuasion is not a threat, it is manipulation. What does unfair mean? It means whatever it would mean in regular English. It doesn't have any special legal meaning. But something about these circumstances strikes a reasonable person as being a really unfair use of their position. To overcome the will of the other party, meaning that the other party thought that they didn't have any other choice but to agree to this contract. You virtually never find a successful case of undue influence without the existence of a fiduciary relationship. Let's go through what a fiduciary relationship is. It's defined as a relationship of trust and confidence. A fiduciary relationship assumes that the parties have the same interests, that they are assumed to have the same goals in mind. How would you prove that? Normally, courts maintain that parties to a contract must make reasonable steps to protect their own interests. Courts won't go back and fix something that you should have, in the exercise of reasonable care on your own behalf, been taking care of yourself. Courts protect those who protect themselves, and you can't successfully run and cry to a court later if you've entered an agreement that you now regret. An exception, along with fraud, misrepresentation, and a few other theories we'll be covering, is undue influence. There are certain legal systems that recognize that the parties justifiably trust the other party and don't take the protective steps they normally would have taken. Under these circumstances, the courts will allow remedies for those unethical jerks who take advantage of the situation. So, what's an example of a fiduciary relationship? Suppose that you go and buy a used car and the car dealer, who you've never met before, says, "Mr. Stein, Jason, can I call you Jason? I won't be happy unless you're happy, and you won't be happy unless you get the car you deserve. I want you to be happy. Sign here. There's no time to read or explain it. That car is yours." Would you sign it? Of course not. Look at the motivation. You, the buyer, do you want to pay a lot for that car or a little? Well, a little, of course. The car dealer, does he want to get a lot of money for that car or a little? Well, he wants a lot. You don't have the same goal. You have different goals. This is how typical commercial arm's length transactions work. The parties have different goals. The dealer can act like he's your friend all he wants, but you're not an idiot. You understand that his attempt to imply friendship is furthering his goal of reducing your perception that you are on opposite sides of this transaction. Now switch it. Suppose you go visit your mother who says, "Jason, I don't have time to explain it, and you don't have time to read it. The bank is closing at 5 o'clock. Just sign here. I'll explain later." Would you sign it? Most of us would. Why? Because we trust our mothers. Why? Seriously, why do you trust your mother? Look at the motivation. Why would your mother want you to sign financial documents? For whose benefit? Well, yours or your family's. Whose interests would you like to further? Again, you'd like to further your interests or your family's interests. Therefore, you and your mother in this hypothetical have the same goal. You and your mother both want to further your or your family's financial goals. This is when there is a fiduciary relationship, when the parties presumably have the same goals and justifiably trust one another. Now, if you have a different kind of mother, you'd get a different answer. But for our purposes, I hope you can see that the interests are normally aligned in that kind of example. With whom do you have a fiduciary relationship? In addition to trusted family members, it would certainly include professionals, for example, your doctor, your lawyer, accountant, employer, employees, any other interests where you can see that the interests are supposed to be aligned. For example, if your doctor says you need to have your appendix removed, for whose interest is your doctor making that recommendation? It is supposed to be for your health. Now, why are you getting your doctor's advice? Well, again, it's for your health. So again, the doctor and you are supposed to have the same interests. That's why your physician is your fiduciary. She has a fiduciary relationship with you. She is not supposed to recommend that you have your appendix removed just because she needs the money from the procedure. That would be a breach of her fiduciary duty. Now, if you're unhappy with your purchase of your car, in our example with my friend, after signing a contract without reading it, is a court likely to rescind or reform an agreement? Of course not. What if you signed a document after your mother had you do it, and it turns out that your mother is defrauding you? Is the court likely to rescind or reform that agreement? Of course. Mom has abused her fiduciary relationship using unfair persuasion so that you did not act to protect yourself. You didn't know you needed to. So you won't see remedies for undue influence typically without the existence of a fiduciary relationship. Duress is very similar to undue influence, except instead of unfair persuasion, it's a threat. It's a threat that overcomes free will. There's nothing in here about fiduciary relationships. That's not part of duress. An example of duress would be, suppose I hold a gun to your head and say, sign the contract. Assume that you believe this is really a gun, it is loaded, and I would really shoot you if you didn't sign. Would you sign? Well, of course you would. Great, then you've accepted my offer. Do we have a contract? Of course not. You didn't freely agree to a contract. There was a threat. You had no free will. Duress cases are very unusual in contracts, thank heavens, but I do point out that it is grounds for rescinding a contract. Our last grounds for rescission or reformation of a contract is mistake. It's possible, but not common, to get a remedy on the grounds of mistake. Compare unilateral mistakes with mutual mistakes. A unilateral mistake is where one of the parties made a mistake, the other party didn't. Typically, there's no remedy for a unilateral mistake unless the other party knew or should have known about the mistake. A bilateral mistake or mutual mistake, on the other hand, is where both parties or all the parties are mistaken. A court may very well then step in and provide a remedy if it's a bilateral mistake. For our purposes, use the maxim of courts protect the reasonable expectations of the parties. Ask yourself, did that party act reasonably in their conduct? If so, a court's much more likely to provide a remedy. Let's take some examples. First, Steve goes to see a used car being sold by Brian. Steve misread the odometer. The odometer accurately listed the car's 50,000 miles, but Steve mistakenly misread it and thought it said 20,000 miles. The Kelley Blue Book price for a car of this description and 50,000 miles is about $12,000. Steve offered to buy the car for $13,000 and Brian accepted. Later, Steve sought to rescind the contract on the basis of mistake. Is Steve likely to be successful? First, start with whether this was a unilateral or bilateral mistake. Well, it was a unilateral mistake. It was only Steve who made a mistake. A court is unlikely to provide any remedy here because it was a unilateral mistake. If Steve had been more careful about looking at the odometer, this would not have occurred. Therefore, Steve bears the loss of this transaction. Secondly, let's look at this example where Kathleen bought what she thought was an antique stickly desk owned by Stephanie. Stephanie was an experienced antique dealer. Both Kathleen and Stephanie believed incorrectly that the desk was a genuine stickly. Its value as a stickly desk would have been $20,000. As a reproduction, it's worth $500. Kathleen paid Stephanie $20,000 and later discovered it was not a real stickly. When Kathleen seeks rescission on the grounds of mistake, is she likely to be successful? Well, now we're talking about a mutual mistake, and therefore a court is very likely, assuming the parties acted reasonably, to give a remedy. In this case, Kathleen was buying it from someone who was a specialist who professed that she understood what a stickly desk was, and the price difference is very large. You simply would not have paid remotely that much if you had any doubt that the desk was truly an antique. A court is very likely to give a remedy in this example. Now let's try this example. A school district sent out an RFP, which means request for proposals, asking dairies to bid on providing milk to a school district for the school year. So the school district would have said, here's how much milk we anticipate needing, and here's how we would need it delivered, and how much would you charge us for that much milk? The school district received 3 bids. Best Dairy bid $710,000, Cantor bid $730,000, and Davis bid, take a look at that number. Take a look at what's wrong with that number. Now the school district, as most government contractors do, accepted the lowest bid, which is the Davis Dairy of $74,200. Now Davis seeks rescission. Are they likely to be successful? Are we talking about a mutual mistake or a unilateral mistake? Well, who made a mistake here? Davis made a mistake because they misplaced both the comma and a decimal point. The school district did not make a mistake. They read $74,200 and they said that's the lowest bid and that's the bid we want. So we're talking about a unilateral mistake. In general, you will not get a remedy for a unilateral mistake. In this case, however, did Bayfield School District know that Davis made a mistake? There's at least a couple reasons why that's true. First off, the punctuation is wrong. You can't have 3 digits after a decimal point for dollars. How else does the school district know that number must be wrong? Because the other 2 numbers are off by a factor of 10. It's impossible that Davis is seriously bidding $74,000. It's a tenth as much as the other dairies are bidding. Therefore, a court would probably say that the school district either knew or they should have known that Davis's bid was a mistake. We don't let parties take advantage of unilateral mistakes if they know that that's what's happened. Therefore, a court is likely to provide a remedy in this case. Now let's sum up these 5 grounds for remedies. Remember that even though technically it appears that there is a contract, there was offer, acceptance, and consideration, we've studied 5 grounds: fraud, misrepresentation, undue influence, duress, and mistake, that may allow a court to set aside or modify a contract. And we've been introduced to 2 new equitable remedies: reformation and rescission. And that concludes our discussion.